Hi, I'm Phil Summa from Summa PLLC, and today I want to just give you a few short thoughts on trademarks and what you need to keep in mind with respect to the legal overlay of trademarks. The three things I want you to remember today are: first, trademarks go with trade; secondly, the likelihood of confusion; and third, sight, sound, and meaning. So let's take those up in turn. First of all, when we say trademarks go with trade, we mean a couple of things. One thing we mean is that there are no secret trademarks. So if you have a good idea for a trademark and you write it down and you put it in a file, you have unfortunately not protected any of your rights at all. Trademarks need to be used in commerce to gain rights. Now, fortunately in the United States, we have what we call a common law basis for trademark rights, meaning that rights are fundamentally based upon the use of the trademark in commerce. So that's why we say trademarks go with trade. But we mean more than that. So for example, as I look at the camera into which we're recording this, it has a trademark on it. Well, the trademark is associated with cameras and optics, but it wouldn't be associated with, say, hot dogs or olive oil or anything else like that. So you could have the same trademark on a camera be totally separate and owned by a different party from the same trademark on a bottle of olive oil, because trademarks go with trade, and if the trade is different, then the trademark rights will be considered differently. The second thing I want to talk about is the likelihood of confusion. Trademark rights, both offensively and defensively, are evaluated on the basis of the likelihood of confusion. Is the relevant customer likely to be confused by the use of similar trademarks on similar goods and services? Notice that I didn't say anything about things being identical. And a lot of times when we talk to people in an introductory sense, they think just adding an S or changing the letter F to PH or K to CH or vice versa, that these can create trademark rights. And the answer is no, they might still be confusingly similar with one another. You also need to recognize that the trademarks do not have to be identical to be confusingly similar, and they do not have to be for the same goods. So again, as I look at this camera, maybe a company that had film would have to use a different trademark than what's on the camera, because otherwise it would be assumed that they're all in the area of photography, and that could be confusing to the purchaser in the ordinary course of business. And again, trademarks go with trade, so the ordinary course of business can be quite different. So if you're the Boeing company selling airplanes, you are in a different channel of trade than the person going to the big box store to buy detergent for soap, and you are evaluated legally differently. Then the third thing I want to point out about the likelihood of confusion, or the third point I raised that goes along with the likelihood of confusion, is sight, sound, and meaning. So that when we look at trademarks to see if they are confusingly similar, either offensively or defensively, meaning is somebody infringing my rights or am I infringing somebody else's rights, we want to look at the trademarks in terms of sight, sound, and meaning. What do they look like? What do they sound like? And what do they mean? So those are the introductory steps to analyze trademark situations. Trademarks go with trade, likelihood of confusion, and sight, sound, and meaning. Thank you.